The officers were looking for a drug shipment. Someone had used the address to receive a package containing marijuana. The address belonged to Calvo, the mayor of Berwyn Heights, Maryland. The officers did not know that. They also did not know that the package had been left on his porch by the actual smugglers, who were using residential addresses to receive shipments and then retrieve them before anyone inside knew the packages had arrived. What the officers did know was that a drug package had been delivered to that address. What they did was execute a no-knock raid. They burst through the door. His mother-in-law was cooking dinner. His wife was upstairs. And then his two black Labrador retrievers ran toward the noise. The officers shot both dogs. They killed them both. One of the dogs was shot while running away. Calvo was not arrested. He was not charged with anything. He was, in fact, cooperating with a drug investigation he had nothing to do with. The officers left. His dogs did not. I am Ben. Today, I am going to explain what the law says about police and your dog. Why shooting a family pet during a police encounter is almost never treated as misconduct. What the courts have actually ruled on this question, and what you can do if it happens to you. The hook. An estimated 25 to 30 dogs are shot by police in the United States every single day. That number comes from a Justice Department report commissioned after law enforcement agencies began tracking these incidents under public pressure. 25 to 30 a day means somewhere between 9,000 and 11,000 dogs killed by police every year. Most of those shootings are never reported beyond a local news brief, if they are reported at all. Most of the officers who fire those shots face no discipline. Most of the families who lose those dogs receive no compensation, and the legal framework that allows this to happen is not a loophole or an oversight. It is the intended result of how courts have interpreted the Fourth Amendment when it applies to animals. Here is the thing I want you to understand before we go further. The legal standard that governs these shootings has nothing to do with whether your dog was actually dangerous. I will come back to exactly why that distinction matters. The what. Under the law, your dog is property. That is the legal classification that governs everything else in this conversation. Not a family member, not a companion, property. Like a lamp or a car. This matters because the Fourth Amendment, which prohibits unreasonable searches and seizures, applies to property. Courts have consistently ruled that shooting a dog constitutes a seizure of property under the Fourth Amendment. Your dog is protected not as a living creature with rights, but as an object you own. But the Fourth Amendment does not prohibit all seizures. It prohibits unreasonable seizures. And what counts as reasonable is determined by courts after the fact, using a standard called objective reasonableness. An officer's use of force is considered constitutionally permissible if a reasonable officer in the same situation would have perceived the animal as a threat. The key word is perceived, not was a threat, perceived as a threat. Courts do not ask whether the dog was dangerous. They ask whether the officer's belief that the dog was dangerous was reasonable given what the officer knew at the time. These are not the same question. One requires an assessment of actual danger. The other requires only that the officer's fear was not obviously wrong. The result is a standard that is very difficult to fail. An officer who shoots a dog can almost always point to something. It barked. It moved toward him. It was a large breed. It did not stop when commanded. Courts have accepted each of these as sufficient justification. The history. The legal framework courts use today comes primarily from a Sixth Circuit Court of Appeals decision in 2007 called Brown v. Battle Creek Police Department. Officers executing a search warrant shot 2 dogs, a pit bull, and a Rottweiler, that they said were charging at them. The court applied the objective reasonableness standard and held that shooting a dog during a search does not violate the Fourth Amendment, as long as the officer reasonably believed the dog posed an immediate threat. The Brown decision became the model for how courts across the country handle these cases. Since that ruling, courts have routinely dismissed Fourth Amendment claims arising from police shootings of dogs unless the plaintiff can show that no reasonable officer could have perceived the dog as a threat. That is a very high bar, and it flows from a Supreme Court case that had nothing to do with dogs. Graham v. Connor, decided in 1989, established the objective reasonableness standard for all use of force by police. The court held that force must be evaluated by what the officer knew at the moment it was used, not with the benefit of hindsight. Courts applied this standard to dog shootings, and the result is a constitutional framework that gives officers nearly complete discretion over a decision that ends badly for thousands of families every year. The cases. Calvo testified before the Maryland State Legislature and then before a United States Senate subcommittee following the raid on his home. His testimony helped pass a Maryland law requiring agencies to report data on no-knock raids. The officers who shot his dogs were not disciplined. The department said the shooting was justified because the dogs had been moving toward the officers. In 2013, a man named Leon Rosby was recording police activity on a public street in Hawthorne, California. Officers asked him to move away. He walked back to his car. His Rottweiler jumped out of the vehicle. Officers shot the dog 4 times as it approached them. The entire incident was recorded on video by bystanders and viewed millions of times. The officer involved was not charged. In Filer, Idaho in 2014, a family's dog was shot during a routine welfare check. The dog was a small mixed breed. The officer said it had approached him in a threatening manner. The case was reviewed and closed without discipline. In Indianapolis, between 2015 and 2018, the city settled 12 separate civil lawsuits involving police shootings of dogs for a combined total of approximately $260,000. In none of those cases was the shooting officer disciplined. A study by Houston's Police Oversight Office found that dog shootings increased following a period of expanded no-knock warrant activity. The study noted that officers at the department received an average of less than 4 hours of training on how to handle dogs during their entire careers. Less than 4 hours. For a job that, statistically, involves encountering dogs at dozens of properties every year. The numbers. The Animal Legal Defense Fund estimated in a 2020 report that law enforcement kills between 10,000 and 20,000 dogs per year in the United States. Even at the low end of that estimate, a dog is shot by police every 52 minutes. The Puppycide Database Project, an independent research effort, compiled media reports and public records requests across all 50 states between 2010 and 2017 and documented over 5,000 individual incidents. In less than 1% of those incidents did the officer face any form of discipline or criminal charge. In a survey of 114 law enforcement agencies conducted by the National Canine Research Council, fewer than 10% of agencies had any formal written policy governing when officers were permitted to use lethal force against animals. Fewer than 10%. That means in more than 9 out of 10 agencies, the officer deciding whether to shoot your dog is making that decision with no departmental guidance whatsoever. The only governing standard is the constitutional one, whether a reasonable officer would have perceived a threat. The law. There is a second legal doctrine that compounds the problem. Qualified immunity shields officers from civil liability unless their conduct violated a clearly established constitutional right. For dog shootings, courts have generally not found clearly established law prohibiting the shooting of a dog that an officer perceived as threatening. This creates a layered result. The shooting can be deemed constitutional under Graham. And even if a court disagrees that it was constitutional, qualified immunity may still bar your civil claim. An officer can shoot your dog, face no criminal charge, face no departmental discipline, and be immune from civil liability, all within the same legal system. The states that have made the most progress on this issue have passed laws requiring training, mandating reporting, and in some cases, creating a separate cause of action for intentional harm to companion animals. California, Maryland, and New Mexico have each taken steps in this direction. Most states have not. What this means for you. If law enforcement is going to be on your property for any reason, whether it is a warrant, a welfare check, or a neighbor complaint, secure your dog before officers arrive if you have any advance notice. Your assessment of your dog's behavior is irrelevant to the legal standard. What matters is the officer's perception in the moment. If officers arrive without notice, verbally announce your dog's presence and ask for a moment to secure the animal before officers enter. Make this request clearly and calmly. Some departments have policies requiring officers to accommodate reasonable requests to secure pets. Making the request creates a record that you attempted to prevent the situation. If your dog is shot during a police encounter, write down every detail immediately. The time, the officers involved, what was said, what your dog was doing, where on the property the shooting occurred, whether video cameras were present. Request all body camera footage and incident reports through public records laws as soon as possible. Footage is routinely deleted after a set number of days unless a hold request is filed. File a complaint with the department's Internal Affairs or Civilian Oversight Board, even if you believe nothing will come of it. The complaint creates a record. If an officer has a history of shooting animals, that history can be relevant in subsequent civil litigation. If you pursue a civil claim, you need an attorney who handles Fourth Amendment civil rights cases specifically, not a general personal injury attorney. Dog shooting cases require knowledge of the objective reasonableness standard and qualified immunity doctrine. That combination of issues is not common in general practice. The complete picture. Your dog is protected by the Fourth Amendment as property. That protection is real, but narrow. It requires that any seizure, including a shooting, be objectively reasonable from the perspective of the officer in the moment. It does not require that the dog was actually dangerous. It requires only that a reasonable officer could have perceived a threat. The gap between those two things is where most cases fail, an estimated 9,000 to 11,000 times a year, in agencies with no written policy on the subject, by officers with less than 4 hours of training. Understanding what the law allows is the first step. Securing your dog and requesting time to do so before officers enter your property are actions you can take right now that may make a difference if you ever face this situation. If this was useful, subscribe. New video every day. I will see you tomorrow.